All right, thank you everyone for joining us for today's webinar. It's going to be part 2 of a 3-part series. And we're focused on business owners, giving them financial advice and information that they need in their businesses. As you know, our monthly webinars are from the perspective of an estate planning attorney, a financial advisor, an accountant, and we talk about finances, everything you know, and trying to educate you and get information out to you. Today's webinar is presented by Yuri Yu. She is a certified public accountant. Her office is located in Fullerton, California. Right now she's on maternity leave, so she'll be back for next week. Next month. Donna Lee is a certified financial planner. Her office is located in the city of Orange. And myself, I am a estate planning attorney. I do probate and living trust, and we have offices in Buena Park and Mission Viejo. So these are our pictures. We're not affiliated. If you have any questions, please type it in the chat below. If there's time remaining in the webinar, we will try to answer them as best as we can. Please note this webinar is recorded. We do discourage any type of screenshots or recording. Let us know if you need to do that. Otherwise, Donna, who do we have as our guest speaker for today?
Well, we are very excited to present a topic that is very relevant to all of us, whether we own businesses or not, whether we are currently employed or not. So we are very honored to have Sanjay Sabarwal with us today. Sanjay is coming from a long history of participating in community service. Sanjay has gotten involved in the legal field to continue his service to others. After graduating from UCLA with a degree in English and political science, Sanjay took a year off to do AmeriCorps, where he taught English in Kentucky at an underserved school. Sanjay has continued to display his passion for improving the lives of others throughout his professional career. He currently volunteers to speak at schools through the Youth Business Alliance program and participates in giving out food to the homeless in Stanton, California with the Illumination Foundation. Sanjay truly believes that clients deserve to feel heard and taken care of, and maintains this value throughout his work as an attorney. Sanjay Sabarwal focuses his practice in the areas of employment law, family law, and personal injury law. In addition to his current practice focus, Mr. Sabarwal has experience in business law, wage and compensation, partnership disputes, and mediation. Mr. Sabarwal is a member of the American Bar Association, Los Angeles Bar Association, South Asian Bar Association, and Orange County Bar Association. He also serves on the advisory board for Youth Business Alliance, which connects entrepreneurs to speak at underserved schools in Los Angeles County. He is also a board member for the Artesia Chamber of Commerce. Mr. Sabarwal is admitted to practice in all California state courts. So with no further ado, I want to introduce you to my good friend, Sanjay Sabarwal. Thank you for joining us today, Sanjay.
Thank you so much, Donna, and thank you so much for the bio. I know it was a lot of stuff, so in hindsight, I probably should have cut that down a little bit before I send it over to you, but thank you so much for doing that for me.
That's great.
And do I just, okay, there you go. So I kind of want to do the legal disclaimer. I'm gonna, how do I go back? She's going through all of it. So I'm gonna sit there, see if we can pause it. Okay. I'm gonna give the legal disclaimer only because there are two reactions when I do that. One is that somebody will read the disclaimer and ignore it and just start implementing everything that they hear, assuming that it applies to them. And so my caution to a lot of people is that this is not legal advice. This is just for informational purposes only. And give me a call, ask me questions. I don't charge for things like this because I want people to feel comfortable to ask questions and come in. And secondly, people also panic because they feel like, oh my God, what's being talked about, I don't do in my business, and start panicking. The goal, again, is not to get people to be panicked, it's to get informed. So with that said, I wanted to go over the agenda quickly. Sorry, Sophie, I don't know why it's going back and forth. I'll go over my background quickly, and then we'll jump right into it. Can employers make vaccines mandatory? Short answer, yes, but we'll go through the exceptions as well. And mainly, I wanted to make sure that we cover why vaccines are important and what are the different things you need to do to accommodate, go over the federal law as well as the state law, get into also masks since people have very strong opinions on them. And finally, if we have time, I do want to keep some time available for questions and answer. We'll talk about what the courts are doing in terms of wrongful discharge claims compared to COVID-19 mask mandates. So this is giving away all my presentation, but I'm going to try to see if I can go back. Sophia, do you know if how I can go back to it? It's it's showing me all the entire slides, or I could just go through mine. So
it's like going by itself. Sanjay,
okay.
Is it okay if I control the screen?
Yes, please.
Okay.
That might be much simpler.
Yes.
Technical difficulties here.
Hey, but this is what makes it fun, because at least
That's right. That's right.
Okay, this was a legal disclaimer.
And then we'll just go to the agenda. We can just skip to the agenda, and then we'll the background. So since Donna did such a great job, I just wanted to throw in a few things from my background. Sophia, we'll go to the next slide. Namely that I want to make people understand that I've been an employer, a landlord, a tenant, as an employee and an employee. So my practice focus really is for employers and employees. I'm one of the unique practices, because normally most lawyers pick a side. They're either plaintiff side or defense side. Because I've been on both sides currently, and because of my knowledge, I am comfortable representing both parties, in the sense that if an employer, my current client roster has half of it is employer-based and half of it is employee-based. And so I want to make that clear to people that the background helps in that way. So let's go into the presentation. Yeah, we can just pause.
I'm sorry. It keeps on going by itself.
You can just pause it. I have mine. And then again, I did mention this to Donna and Sophia that I do have the presentation. So anyone that wants it, let Donna and Sophia know. They have a copy of my presentation. Feel free to send it to anyone that requests it, ladies. So let's talk about the federal guidance. And so obviously, the EEOC has come out with guidance that for this year, in July 15th, that employers can require all employees physically entering a workplace to be vaccinated. And but employers also need to make sure they're complying with the reasonable accommodation provisions of the ADA Act and Title VII. So in federal law, employers can offer incentive, which is some people were doing this. They're offering bonuses, they're offering time off, they're offering gift cards. They're doing whatever they could to encourage people to get the vaccine, right? However, the offers and inducements cannot be coercive. It can't be like, oh, you have to get vaccinated in order to get this, in the sense that you can't make people feel like pressured. And so the federal guidance was a little unclear on, well, what do you mean by incentives? So California steps in, which is the California Department of Fair Housing and Employment. I won't get into acronyms because I don't want to confuse anyone. So I'm just going to say California law versus federal law. So according to California law, employers may require employees to receive an FDA-approved vaccination. Well, some employees were saying, well, you know, the FDA hasn't approved it. It's under emergency status. Well, that's changed as recently as last month with Pfizer and Moderna getting the FDA approval. So employees can no longer say, oh, it's not FDA approved, because the vaccinations are FDA approved. However, you cannot pick and choose, employers, to decide, hey, person is, I think, is a different kind of politics. I'm going to only ask the people that I assume are not getting the vaccinations. If you're requiring and you're asking employees if they're vaccinated, you must make sure you're asking everyone. The mistake a lot of employers tend to make is they unfortunately will hear from someone or think, with everyone having so much access to social media, they can get confused, or they can feel like they can ask employees personal questions. So I encourage my clients to make sure you're not really picking and choosing, and you're asking all employees. Now, the other thing is, if you are going to ask and an employee does say that they may have a disability or they have a sincerely held religious belief, we'll get into the exemptions. You must get into what is called a reasonable accommodation, which means you have to have an interactive conversation with the employee. So, and more than anything else, and this is the laws that are happening right now, you cannot retaliate against anyone for asking, engaging in what we call a protected activity. Now, some of these are terms of art. Well, what's a protected activity? Well, asking for a reasonable accommodation or expressing concerns about workplace safety. Hey, I don't feel comfortable coming into work because I don't think you guys have enough. The office is not offering enough masks. There's not enough PPP. You're not socially distancing. I'm not comfortable being in the office with a lot of employees if there's no plexiglass barriers. And I'm sure some of us have seen this in other businesses. The conversation has to be a conversation. If somebody's complaining, it's not like you have to apply and do it right away, but you definitely need to have the conversation and go through options with employees, have a discussion with them. So let's talk about the exemptions. So the first one being medical, right? So people who have medical conditions that make vaccines inappropriate are exempt from mandatory vaccines. So California requires that for those employees, you must make a reasonable accommodation. So, that could be, again, I keep saying the word conversation because you cannot automatically say, I'm going to make you, because you have a disability, I'm going to make you a remote. You need to ask them, hey, can we reduce your hours? Can you work remotely? What do you think? What works for you? What does your doctor say? What can you do? Ask open-ended questions, engage with the employee, make them feel like they're being heard. So now, if they are objecting and you're not engaging in an interactive process, you're asking for trouble. So, and now there are exceptions to that too. That doesn't mean as an employer I have to automatically give that. So if I'm only a one employee and that person needs to come into the office because the work that they do requires them to be in the office, and that person is saying, hey, I don't want to come in, he or she is placing an undue burden on the business, and you can't afford to do that. Now, I want to be careful because undue burden is a common defense that employers use, but it's a high standard. So it really must be impossible for you to be able to accommodate. So I advise clients to not jump to that saying, well, it's not going to work for me, it's inconvenient. That's not an undue burden. So I want to caution people. Now, the second exception is the one that I think has confused a lot of people. I want to be very clear. The personal belief exemption was eliminated from California law in 2015. So people that have personal beliefs against vaccinations, unfortunately, are not covered under these laws. However, if you have a religious belief, now this is like, I want to be clear. You must be able to document. You can't just say I have a religious belief. If you're, let's just say Jehovah's Witnesses, or I mean, it's common in certain particular religions that have prohibitions against doing extra things, then you are exempted from taking a vaccination. So beyond that, you cannot sit there and ask for a personal belief, say I don't want to get vaccinated. Now, if I have an exemption and you ignore it, yes, I can go after an employer. It can be liable for retaliation. So be aware of that. Now, I'm going to jump to Sophia, Donna, do you want me to answer any questions now, or should I continue?
We don't have any questions in the chat, so please continue.
Okay, so that's vaccinations. I wanted to cover that first. Since we have time, let's talk about masks. So when are masks still required? And there's been a confusion. Obviously, as we know, we had the shelter in place, we had the masks, then we had the mask off policy, and then if you're vaccinated, you can get. So currently, the way I tell employers to consider it, if there is an outbreak in your area, regardless of vaccination status, all employees must wear masks indoor during outbreaks, and outside when they cannot physically distance, or they cannot be, you have a very small patio and you can't really have 6 feet apart, then employees must be masked. So an employer's obligation is they must provide, now I'm going to say must because if you're unvaccinated employees, you're required to provide N95 respiratory masks for voluntary use. You can't require them, especially if they're working indoors or they're riding in a vehicle and other people. Now, what I recommend in general to a lot of my clients is provide masks to all employees. Why even have the hassle? Or, if you can, and right now PPP has become very common and very easy. In the beginning, it was hard to get. I recommend to my clients generally provide masks to all employees, because the more you can show that you are trying to comply, the more it can support you if there is a wrongful discharge claim, or somebody complains that, hey, I don't feel safe. Because if you can sit there and outline, hey, I've had several employers call me, and HR luckily was able to document that, hey, this employee complained saying they weren't feeling very safe. Well, we provided in every area, every employee had access to masks, and we put up signs. We had sanitizers in every hand stations that we could. We also marked places 6 feet apart. So when you can show those kind of things, it helps you if things go sideways, so to speak.
Sanjay, is there a definition for outbreak?
Currently, I think it's basically ordinances are depending. I normally, CDC is the go-to, and it depends on what county you're in. So if you are in Orange County or LA County, I recommend going to their sites to see what's considered to be an outbreak. But generally, I recommend for LA County, I know is definitely more stricter than Orange County. So right now, if you cannot, again, it's on a weekly basis. You literally have to go and look up and see what the stats are. So it's extra work. And generally, if I'm being honest, if you're a smaller employer, it's sometimes easier to accommodate and to do that. But if you're bigger employer, it definitely behooves you to check the sites regularly, because things do change rapidly. So it really comes down to what area are you in, and if it looks like you're more likely to, and then again with the Delta variant, and it really comes down to, are you following all the other measures? If you are, then you don't have as much to worry about. So to answer your question, it really comes down to, you're gonna have to check what are the cities saying in their areas.
Thank you.
Now, can an employee refuse to wear a mask? And I said this to Donna and Sophia earlier, my favorite answer, which drives clients, it depends. Now, if there's an employer mandate, if the employer has decided that all employees are going to wear masks, or there's a state or a local mask mandate, employees must comply. Unless, again, there's exceptions. They have a medical condition which makes wearing a mask very dangerous. Now, I'm not a health expert, so obviously, if they have documentation showing that their provider is saying, hey, this person cannot breathe properly with a mask, then follow that direction. Also, if the mask interferes with the performance of the person's job. Now, this does not mean, I want to be very clear, because people have said, well, I get muffled and it makes it hard for me to talk. That's not really interfering with the performance. Now, if you cannot breathe, or you cannot sit there and communicate to the point where people are not understanding, if you have double masks, then it makes sense. But really, that's not considered interference with the performance. Now, finally, this one I'm going to defer to, if a mask creates a hazard, and that's a term that's defined by OSHA. So I can send people the OSHA guidelines, because they're very specific as to what's considered a hazard. So, for example, it could be a mask is interfering with smelling or hearing, and they're working on heavy machinery, and that's a danger where if they don't hear or smell the different sounds, and that could be dangerous to them, that can be considered a hazard. So those are the exceptions, really. Now, there are other exceptions as well. If your employees are mostly working remotely, obviously you can't monitor that and they're working at home. You don't know, there's not much you can do about that, right? Now also, if you only have one employee and they're the only person, like currently right now in my office, my assistant is not here. I'm the only working in this office right now. I don't obviously have to wear a mask because I'm not coming into contact with anyone else. So employees that are working from home, employees that are like working from a location which they pick. For example, they decide they're working remotely and they want to work at Starbucks. They're working at a friend's house. Places that an employer cannot control are not covered by the mask mandate. Now, if an employer does tell people, or I want you to go to X, Y, and Z place, you got to be careful. So generally, advise my clients, do not control. If you're going to let employees work remotely and they're getting their work done, please let them work remotely. Don't make the mistake of not letting them, telling them where they should be working from. That's a mistake.
Yeah.
So my final slide, and I feel like I'm rolling through this quickly, so I think we'll have hopefully enough time for questions, is that wrongful discharge. So I've had several of these situations and I've settled them. And that's another thing I do want to let clients know. I have clients that get panicked when they get demand letters or they get served a lawsuit. The reality is 99.9% of the cases that I have dealt with end up settling. What does that mean? The reality is trials are expensive. Most employers or employees or anyone that's as a business going through a lawsuit, unless like you are adamant and you have, you think you are 100% right, I generally recommend that we consider settlement because litigation gets expensive. Now, that's not to say and I have clients that are currently that I'm representing that have said, we're going to trial because this X, Y, and Z employee is completely lying. That is not true what they're saying. And we don't want to set a bad precedent because if we allow this employee to go through and we settle with them, we're sending a message that what we did was wrong and we're not wrong. So I understand that. So, but right now, a couple of interesting cases are coming on. There are employees who were fired or terminated during COVID-19, and they may be able to assert a wrongful discharge claim based on several different scenarios. So especially if an employee was terminated because they complained about workplace safety, which is what I talked about earlier. Mm-hmm. If an employee says, hey, I don't feel safe, and my clients or potential client decided, instead of dealing with that, they decided to fire that employee, they do have some things they have to worry about for retaliation. Or if an employee took a medical leave, that, hey, I have asthma. I have a client right now that went on medical leave because they have asthma and they cannot afford to come in. Well, an employer insisted they come into work. And unfortunately, the employee then decided to resign because they're like, I'm at high risk. I cannot come into work. So they have a potential wrongful discharge claim. And then, or we had a lot of people, I think I was surprised to hear about this one. This is when the shelter in place orders were in place, and there were employers are insisting employees to come in, and they were terminated because they did not come into work. Guess what? They have huge potential liability at this point. So I tell people, if you're going to make a decision based on COVID-19 in general, please talk to someone before you make a drastic decision like that. Have the conversation, even if you think the person is lying, even if you think the employee is making it up, even if you think that it's a personal belief, not a religious belief, please talk to someone before you make that decision when you pull that trigger, because you could save yourself a lot of headache if you can just be guided through that situation. Now, remember, wrongful, I don't know if employees are aware that, under FEHA and the California Labor Code of retaliation, they can be violations also of federal law, which is particularly the ADA, because remember, a lot of people forget COVID-related symptoms or COVID-related sick leave could be seen as a temporary disability, which means ADA, American Disabilities Act, can come into play as well. So not only which can also then trigger the UNRRA Act, which is the California version of the ADA Act. Again, I did say I was not going to do acronyms. I do apologize, but it's important for employers to realize that, even if you feel 100% certain, we have to go through the whole I like to go back to the basics. I sit there and go through and look at all the federal and the California laws that could be potentially affected before I advise clients. So sometimes employers get impatient with me because they're like, well, this sounds like a cut and dry issue. Why are you going through this whole, you're just trying to bill me? And I'm like, no, I need to understand and make you understand how the different laws interact, what the potential liability is, and generally can give you a clear answer if there's enough time given. So, now there has a new case that had come out, which I will send over as a link to Sophia and Donna, which is that, a wrongful discharge claim cannot be based on an alleged violation of a municipal ordinance. What does that mean? When LA County and when Orange County had the ordinances, and if an employee is saying they had no damages, but they're saying, well, I know my business was open or they didn't do it, that's a violation. That's not considered a wrongful discharge because there was no harm, there's no damage. So I want to caution employees to not jump the gun on that. So that kind of covers what the potential scenarios are for COVID-19. And we can open it up to questions, or Donna, Sophia, if you want to ask things, let me know.
Okay, so, we did have a question come in, and similar to the guidelines for employers and ADAs, of course, there is, different burdens that are placed on the employer based on the number of employees. So does an employer with fewer than 15 employees need to accommodate employees under the ADA? That was one question.
So again, it's not, it really depends. And so here's the issue that if you can get, I normally, and I kind of want to say this again, because employees need to feel heard. So if an employee is sometimes asking for an accommodation, you can be cut and dry. And I've dealt with HR directors, and sometimes they're very cut and dry. Well, we only have 14 employees, only 10 of us. There's absolutely no harm in actually having the discussion with the employee, because you get to document it. That, even if you're not liable, even if you're not, if you're not under that claim, if you can show a documentation, because I gotta tell you, I've had employees that were terminated because an HR person said, "Oh no, we don't. This law regulation doesn't apply to us." Guess what? There's still a demand letter that came in for an employer claiming for different things. But guess what? If there's documentation that, hey, this employee X, Y, and Z came on this date, complained about this, we talked about it, we thought about it, and because we're such a small business, we couldn't accommodate them because of X, Y, and Z reasons. It was not just because we're under 15, because I gotta tell you, when you just use numerical explanations, it doesn't read well to a jury. So you have to assume at some point, if this goes to trial, were you being cruel? Were you being insensitive? Were you being uncaring? All these things kind of play into it. And you have to assume that if you can show documentation that, hey, this employee came to my office, I heard them out, I looked into it, and we went through everything we could, and unfortunately we couldn't accommodate that. And that's a stronger argument than saying, no, ADA doesn't apply, sorry, go try somewhere else. Because like I mentioned, the UNRRA Act, because California has the UNRRA Act, which doesn't have that numerical limitation, state laws and federal laws can interact with each other. So it's not always just one area of law.
All right, thanks, Sanjay. We also have a few more questions. I know that you were talking about employees that are already hired, but what about during the interview or hiring process? Can we ask a potential employee if they're fully vaccinated? Can we ask them to see their vaccination card? Can we even post an employee advertisement like Indeed that they require vaccination?
Short answer, yes, but I want to caution, because the CDC has has said that because the medical facilities are so overwhelmed, if an employee or a potential employee is saying, hey, I have the vaccination, I don't have the documentation, I can get you the doctor's note, you get to be patient. And if a person is saying, I have the vaccination, but I don't have the records right now, or I have a disability, but I need some time to get the doctor's note, I want to tell people to exercise caution. Don't jump the gun. It is taking a while to get records. I'm having a hard time. We're currently in trial mode and getting subpoenaing healthcare providers. They're overwhelmed. As you know, Sophia, people are having a hard time finding employees. So I want to caution people. So yes, you can put that as a requirement. Now, again, be aware of the exemptions, because you want to find out. If somebody says, hey, I have a disability that qualifies as an exemption, you must hear that employee out or potential employee out. So yes, you may, but be aware of the exemptions.
All right, very good. The other question, and I don't know if this has actually been dealt with in the courts, so you may or may not know, but if an employer requires vaccination and then the employee does get a vaccination, but then has an adverse reaction or something happens, is the employer now liable to this employee? Are they protected?
They are liable in the sense of liable in the sense of they may, that has been discussed. So it may go under paid sick leave. Now it goes into technically, like I mentioned, symptoms and things. So this could be considered a temporary disability. And so then again, it goes back to the same reasonable accommodation. Can you talk to the employee, see what they need? So that could be a potential accommodation that, hey, we might give you an extra day off to, give you a couple of days off. We would pay for your medical expenses because you had to go to the ER or to urgent care. So those are all potential. Now, again, it comes back to the undue burden. If I'm a small employer and I can't afford for them to be, it really comes down to that balancing act. So it ends up being the same thing. So reasonable accommodation, considered a temporary disability, and interactive discussion with the employee. How can I support you? What do you need from me? And so my favorite answer, it depends.
All right. Thanks, Sanjay. And I think we have time for a few more questions. Now, as employers, sometimes you have to verify like employment records or other things. And what if you suspect that an employee has a fake vaccination cards? Of course, we've seen that in the news, and it certainly is a possibility. Can we ask for medical records as a backup to the vaccine card?
I think the standard is if you have a reasonable belief, and so it really comes down to what is reasonable, right? So if you feel like that person is, and you have documentation or something that shows to you why you don't believe them, they're on social media posting stuff. If you can point to something showing why you don't believe them, yes, you may. But I want to be careful because it's a slippery slope, right? Because employees talk, and someone may have heard something or thought they heard something, or someone doesn't like someone and may say, well, you might want to check into that person. So employers need to be careful. I always hesitate because it can turn into, but like I said, if they have if they know, have reasonable belief, yes, they can definitely require that card.
Okay, great. Donna, did you have a question?
I just had a comment in general. As I talk to clients, what a trend that I'm seeing is, you had mentioned earlier about working remotely, letting them kind of work remotely if possible. Yeah, especially as we get into flu season, I was talking to a client and he was a little bit under the weather. And I mean, it's nothing major, he didn't even have a fever or anything, but he was just, everyone's being extra cautious. So he let his employer know that, hey, I have like a little bit of a runny nose. My daughter has, like a runny nose because she's going to daycare or something. So it's just like a normal cold flu. He was tested and was negative, but the employer basically just told him, you know what? Why don't you just work from home for the next 10 business days? That's 2 weeks of working from home. So it really shows that employers now are really trying to mitigate liability, right? Just sounds good, stay home, work from home, and then come back in 2 weeks after your first symptoms occurred or ended or something like that. So I think it's just worthwhile to note. So when you said that and mentioned that, I was thinking, oh yeah, employers are definitely doing that. So if you're in an industry where your employees can work from home or work remotely, I would definitely encourage you to allow them to, at least for the time being, just to mitigate your legal liabilities.
Since we have a little bit of time, so I'm going to talk about one thing. I know the remote thing sounds very appealing to some employers, especially if they're paying rent and they don't have to pay for rent offices. The big thing that's happening right now is, well, are you reimbursing your employees for using their cell phones? Are you reimbursing them for using the internet at home? Are you reimbursing them for whatever, if it's work related? So, that's another, we're starting to already see demand letters coming to employers saying, hey, you forced me, there was no discussion, you just made me remote. You're telling me to use my internet. I live at home, whatever. I'm using my own cell phone now. I'm using everything on my own, my electricity. Are you going to reimburse me for that? And there are possibly technical violations that are happening, right? Because if you're not reimbursing them, and the other thing is, how do you manage their time? How do you know if you were telling employees in their hourly, especially, right? It becomes, I caution employers, it may sound like a good thing, and yes, you will definitely save money, but be aware that there's a lot more document record keeping that needs to go on when you're requiring employees to work from home. It's not a simple solution like, hey, you just stay home, use your own stuff, because you technically should be reimbursing employees for using their own personal tools for work. They are, and again, I can send and I know sometimes my clients get really annoyed, but I'm like, California is an employee-friendly state, and you must make sure that you compensate employees for all hours worked and all things that they have to use for work. Because if you are expecting employees to use their own cell phones, which is why some employers give out work phones, because it's just, or my wife right now is working for someone, they're paying the car allowance, they're reimbursing her mileage, because it's much simpler to reimburse employees rather than get a claim later on saying, I did all this off the clock work and you never reimbursed me. And those violations can get pretty hefty pretty quickly.
Good point. Good point. I think there's a lot wrapped up in this that is not just, right? There's like multidisciplinaries that we kind of see. So yeah, there's definitely different angles. Thanks, Sanjay.
Sanjay, just one more question. You as an employer may know the vaccination status of your employees. However, if you get asked about others, can you let other people know, like who's vaccinated, who's not? Is it your responsibility to let other people know? And if they ask you and you tell them, is that a HIPAA violation?
Yeah, short answer, yes. For once I can say yes, because there's, as you know, California has very strong privacy laws in effect. So in fact, if you know someone's even infected, you're not allowed to tell employees who's the one that's infected with COVID. So I want to be, you have to be very careful to be sharing personal, because that is a violation. Think about how much I tell people to put yourself in their place. If you're telling people X, Y, and Z, let's assume it's not, okay, vaccination, whether positive or negative, whatever the information that you're sharing with someone, it's personal, and it's my choice if I want to share that or not. If you are sharing without asking for my permission, the law protects you, and there are violations that can get pretty steep, especially HIPAA violations. And so medical history makes me really antsy when employers discuss medical history. Be careful, because you can get yourself in a heap of trouble.
Okay, so if an employee wants to know, well, is everyone vaccinated in this office? What can you tell them?
Again, it comes back to the reasonable. It sounds like let's assume the employee sounds like they're expressing concern. Hey, I feel like not everyone's vaccinated, and so now you go into the ADA as well as the California law. You engage with them, saying, "Well, here's what we're doing. Here's how we're making sure everyone. You do not go into specifics. We're saying these are the policies, and this is what we're requiring all employees to show and do. You can talk about your policies. You just cannot talk about specifics now." And if they're alleging, workforce, it's called a protected activity. They're engaging in a protected activity. That doesn't give them the 100% right to know. It just means they're engaging in a protected. You can't retaliate against them, but you can engage with them and give them information. Just has to be general, cannot be specific.
All right, sounds good. I think that's it for the questions. Let's see. So we're concluding our webinar. And I thank you for joining us today, Employers and COVID-19 with guest speaker Sanjay Sabarwal. We know your time is precious and we strive to provide content that is informative and useful. As you know, this was part 2 of a 3-part guest speaker series for business owners. If you missed last month's webinar, Business Mistakes Business Owners Make with Garam Kang, please visit our YouTube channel for all of our past webinars. In October, we're going to be featuring a TPA, a third-party administrator, Jeremy Yang with Yang's Pension Consulting, Inc. He will talk about various retirement plans businesses can set up to maximize tax deductions, for example, 401ks. And in November, we'll be discussing year-end tax planning and summarizing the tax changes and ways to plan for the end of the year. Be sure to register for our webinars through the link. Thank you everyone for attending. A short survey is going to be emailed to you. We appreciate your feedback. Thanks everyone.